When you gave him that £2,500, did you put that in writing?
No, but I wrote on my bank account, this is loan for tools.
Let's just pause. I'm going to get there in a second. You didn't put it in writing in the ordinary way. You
No.
didn't say, I'm going to draw up a contract,
No.
I owe you £2,500. You did do something. What you say is you gave him this £2,500, and rather than drawing up an agreement, what you did was you made a transfer to him.
Yes.
Yes? And that transfer, the bank transfer, it says on it something important.
Yes.
Let's have a look. Mr. Craig, that's you, £2,500, and it says loan for tools. Now, what you say to me, Janice, is the fact that you have put that on your bank account,
Yes.
your bank account, not
Yes.
his, is sufficient to prove that this was a legally enforceable loan. Correct?
Yes. No?
No. Not by any stretch of the
Well,
imagination.
I'm not a lawyer.
You could say £2,500, Judge Rinder's clothing budget. Who knows?
Yeah.
I have no control over what you write on that bank account. You say that despite bringing proceedings against Alan originally, you left something out of the claim, correct? Mm-hmm. What did you leave out of that original claim?
The dishwasher and the washing machine.
In other words, what we call white goods.
Mm-hmm.
Dishwasher and washing machine.
Mm-hmm.
How much did you pay, Alan, for those things?
£930.
Where's the dishwasher? Where's the washing machine? Where is it?
Nowhere to be seen, Judge.
Where is it?
Spent on bills, Judge.
Now, here's a problem, Marvin. You didn't initiate that claim at the time. So Alan, and I have to construe this on his behalf, may have what in law would be called an abuse of process. In other words, when you sue somebody and it's all for the same thing, you've kind of got an obligation to bring everything at the same time. Otherwise, if you were going to be very malicious, you could sue somebody for little drips over the same issue. Do you see what I mean? This week I'm going to sue you for the floor, you get judgment. And another thing, oh, I forgot the ceiling, another judgment. And you keep somebody on a legal chain for years whilst you sue them over the same issue. And confronted by that, the court would have to say, no, no, you've had an opportunity, you get one go to bring everything. Do you see what I mean?
Yes, Judge.
I presume, bearing in mind you're a professional, you, after you discussed how much you were going to be paid by, sweetie, you put it down in writing, correct?
Yes, I did.
Let's see the contract. Now, the problem with this contract, as far as I can see, is that where is there a date on it? Where's the date? Sir, this is not a contract, this is an invoice.
Yes.
In other words, after you completed the event, you sent her an invoice for what you were owed.
Yes.
Anybody can send an invoice. I could send one to you tomorrow saying, you owe me £1,000 for wasting my time. Here's my bill. Understood, for example. Yes?
Yes.
This was Gio's first business and he wanted to make it a success. However, due to the ill treatment of Gio by some of his customers, i.e. Clyde, Wigs by Marilyn unfortunately had to be liquidated. He uses that word again. You can't be liquidated, sir, unless you're a company, unless, I don't know, somebody puts you in a blender. Clyde, you paid for a service from Gio. You're entitled to that service. It's as simple as that. You paid £175 for 2 wig on a transvestite bog-off deal. You never received either of them in the time that was agreed. I have no difficulty whatsoever coming to the view that this was a clearly enforceable contract and you're entitled to your £175, which is the order of this court. Sir, where you promise to provide a service and you are a sole trader, you are personally fully liable for that sum. I should tell you this, it's a word to the wise, because you do have some talent and you may start a business in due course. If you were a limited company and you did, in fact, get liquidated, as you put it, or become insolvent, this person wouldn't have a personal claim against you at all. It would be against the business. And in the event the business had no money, that would be his problem. He might get a court order, but it'd be worth nothing because the business is broke. Because this was a personal hobby, he's entitled to sue you personally. You're liable for the lot. Understood?
I did state on the paper.
Talking! Therefore, this court awards you £175. You've come to court today in an interesting manner because it's not necessarily a contentious dispute between you. You've applied to the court seeking clarity, really, about the legal status of this loan.
Yeah.
Now, it's a difficult situation. In nearly all circumstances where families lend each other money, on the face of it, what you would say in law, prima facie, on the face of it, there is no enforceable agreement because there's a lack of something called an intention to create legal relations. That means is brothers and sisters lend each other money. The court assumes that in circumstances where one or either party doesn't pay, you're not going to take each other to court. Otherwise, that's all the courts would ever deal with. Don't be stupid. Stay and watch the best Judge Rinder moments. And I'm talking. Understood? Don't be a moron. Subscribe to Judge Rinder YouTube channel. Right now. That's an order.